Hello everyone, welcome to Telugu One Academy and to Mains Answer Rating Program Map for TGPSC and APPSC. So far we have covered the first chapter, the evolution of Constitution, role of drafting committee, the constitutional philosophy and preamble, salient features, basic structure and amendments, important amendments. At the same time we had seen fundamental rights, their nature, scope, expanding horizons of fundamental rights, enforceability, welfare state, distributive justice under the constitution and DPSPs as well. Today we shall see the concept of rule of law and fundamental rights. We shall discuss the question answers from these concepts. So let's start our discussion for today. What do you understand by rule of law? Explain how this idea is reflected in the Constitution of India. క్వశ్చన్లో ఏమడుగుతున్నారు రూల్ ఆఫ్ లా అంటే ఏమిటి అండ్ వాట్ ఆర్ ద ప్రొవిజన్స్ దట్ రిఫ్లెక్ట్ రూల్ ఆఫ్ లా ఇన్ ద ఇండియన్ కాన్స్టిట్యూషన్. సో టాపిక్ ఈస్ రూల్ ఆఫ్ లా, రైట్. సో వాట్ డూ యూ అండర్స్టాండ్ బై రూల్ ఆఫ్ లా అని అడుగుతున్నారు ఇక్కడ, రైట్. సో అండర్స్టాండింగ్ అని ఇలాంటి కాన్సెప్ట్ వచ్చినప్పుడు మనం రాయాల్సింది ఏంటంటే షార్ట్ నోట్స్ ఆఫ్ ద గివెన్ టాపిక్. రూల్ ఆఫ్ లా గురించి షార్ట్ నోట్స్ రాయాలి. షార్ట్ నోట్స్ ఈజ్ నథింగ్ బట్ ద సేలియంట్ ఫీచర్స్ ఏవైతే ఫీచర్స్ ఉంటాయో వాటిని మెన్షన్ చేయాల్సి ఉంటుంది. అట్ ది సేమ్ టైం ఇంపార్టెన్స్ కూడా రాయొచ్చు. నౌ ఇన్ దిస్ వన్ ఐ విల్ కవర్ ద సేలియంట్ ఫీచర్స్, ఇంపార్టెన్స్ ఎట్ ద సేమ్ టైం, రైట్. సో సెకండ్ ఆస్పెక్ట్ ఏమడుగుతున్నారు, హౌ దిస్ ఐడియా ఈజ్ రిఫ్లెక్టెడ్ ఇన్ ద ఇండియన్ కాన్స్టిట్యూషన్లో ఈ ఐడియా అనేది ఎలా పొందుపరచబడిందని అడుగుతున్నారు. అంటే ఇండియన్ కాన్స్టిట్యూషన్లో ఏమన్నా ప్రొవిజన్స్ ఏవైతే ఉన్నాయో రూల్ ఆఫ్ లాని అప్హోల్డ్ చేస్తాయో ఆ ప్రొవిజన్స్ని సెకండ్ పార్ట్లో మెన్షన్ చేయాల్సి ఉంటుంది, రైట్. సో లెట్స్ స్టార్ట్ విత్ ద ఆన్సర్. ఫస్ట్ థింగ్, రూల్ ఆఫ్ లా అంటే ఏంటి, డెఫినేషన్ రాయాలి. రూల్ ఆఫ్ లా డెఫినేషన్ రాసినప్పుడు intro will be good, right. So what is the concept of rule of law? It's a political principle or political doctrine that ensures all individuals, institutions, entities and governments are subjected to and accountable to the laws. దట్ మీన్స్ రూలింగ్ అనేది ఎవరి చేతిలో ఉంటుంది, రూలింగ్ అనేది కొంత పీపుల్ మంద కాదు, రూలింగ్ అనేది లాస్తో చేయబడుతూ ఉంటుంది. లా అకార్డింగ్ టు ద లా రూలింగ్ విల్ బి డన్. దట్ మీన్స్ ఎనీ డిసిషన్స్, యాక్షన్స్ దట్ ఆర్ టేకెన్ విల్ బి ఇన్ అకార్డెన్స్ విత్ ద లా, నాట్ అకార్డింగ్ టు ద విమ్స్ అండ్ ఫ్యాన్సీస్ ఆఫ్ ద ఇండివిజువల్ హూ ఆర్ హోల్డింగ్ ద పవర్స్, రైట్. సో ప్రతి ఒక్కరు, ఎవరైనా ఇండివిజువల్స్ అయినా, ఇన్స్టిట్యూషన్స్ అయినా, గవర్నమెంట్ ఎంటిటీస్ అయినా, ప్రైవేట్ ఎంటిటీస్ అయినా అందరికీ లా అనేది వర్తిస్తుంది. అట్ ది సేమ్ టైం అందరూ లాకి కూడా జవాబుదారీగా ఉంటారు. దట్ ఈస్ ఎ కాన్సెప్ట్ ఆఫ్ రూల్ ఆఫ్ లా. రూల్ ఆఫ్ లా ఈజ్ ఏ ఫండమెంటల్ ప్రిన్సిపల్స్ ఇన్ డెమోక్రటిక్ సొసైటీస్ దట్ ఎన్ష్యూర్స్ individuals, institutions are subjected to and accountable under the law. Two things, it is subjected to and accountable under the law. This has to be written definitely. Another thing is, it is a fundamental for ensuring justice, fairness and equality within the legal system. Justice రావాలన్నా, సొసైటీలో ఫెయిర్నెస్ ఉండాలన్నా, ఈక్వాలిటీ ఉండాలన్నా ఇది ఫండమెంటల్ ప్రిన్సిపల్. రూల్ ఆఫ్ లా అనేది ఒక ఫండమెంటల్ ప్రిన్సిపల్స్. ఒక సేలియంట్ ఫీచర్స్, కీ ఫీచర్స్ చూడడం ద్వారా లెట్ us అండర్స్టాండ్ దిస్ కాన్సెప్ట్ ఈవెన్ ఇన్ డీపర్ మేనర్. ఫస్ట్ ఫీచర్ ఈజ్ సుప్రమసీ ఆఫ్ ద లా. సుప్రమసీ ఆఫ్ ద లా అంటే ఏంటి, లా అనేది అల్టిమేట్గా ఉంటుంది. ఎనీ డిసిషన్ అండ్ ఎవ్రీ డిసిషన్ ఈస్ టేకెన్ ఇన్ అకార్డింగ్ టు ద లా. At the same time, nobody is above the law. Everyone, including the lawmaker, government officials, everyone is bound by the law, right. So what is the importance of this one? It ensures that all the actions governed by established laws rather than the arbitrary decisions, rather than the whims and fancies of the people who are holding these offices. రైట్. సో ప్రతి యాక్షన్ అనేది ఏదైతే చేస్తున్నారో, ఏ డిసిషన్ ఉన్నదో లా ప్రకారం తీసుకోబడుతుంది. నాట్ అకార్డింగ్ టు ద విమ్స్ అండ్ ఫ్యాన్సీస్ ఆఫ్ ద పీపుల్ హూ ఆర్ హోల్డింగ్ దీస్ పొజిషన్స్ ఆర్ హూ ఆర్ హోల్డింగ్ ద పవర్. దిస్ essentially prevents the misuse of power and maintains an order in the society, at the same time it also ensure predictability in the society, right? So importance అర్థమైంది కదా. ఇంపార్టెన్స్ వచ్చేసి it prevents the arbitrary actions, misuse of the power and ensures the order in the society. Second concept is equality before the law. Equality before the law, every individual is subjected to the same laws irrespective who are the persons, right? So with no discrimination, every individual is subjected to the same laws with no discrimination based on race, gender, religion and another social status. What is the importance of this one? It promotes fairness and and justice, ensuring that all people are treated equally under the law. All people are treated equally under the law. This principle helps to protect individual against the discriminatory practices, prejudices, biases and stereotypings in the society. Equality before the law, it protects individuals, against discriminatory practices and biases that are prevalent in the society. Another thing is accountability. Accountability అంటే జవాబుదారీ తనం. Government officials and institutions are accountable to the laws, thus ensuring that they act within the legal boundaries of the act. What is the importance of this one? Again, this again prevents the misuse of power or abuse of power, right? Misuse of power or abuse of power, and at the same time it prevents corruption as well. Thus it promotes honesty and integrity in the officials, in the government machinery. Integrity and honesty in the గవర్నమెంట్ మెషినరీ. ఎప్పుడైతే ఇంటిగ్రిటీ హానెస్టీ ఉంటుందో ఏం ప్రమోట్ చేస్తుంది? దట్ ప్రమోట్స్ పబ్లిక్ ట్రస్ట్ ఇన్ ద గవర్నమెంట్ ఇన్స్టిట్యూషన్స్, ఇన్ ద గవర్నమెంట్ ఆఫీసెస్, రైట్? అకౌంటబిలిటీ ఉంటే ద యాక్ట్ విత్ ఇన్ ద బౌండరీస్ యాక్ట్ చేసినప్పుడు మిస్యూజ్ ఆఫ్ పవర్ ఉండదు, అబ్యూజ్ ఆఫ్ పవర్ ఉండదు, కరప్షన్ ఉండదు. కరప్షన్ ఇలాంటివి లేకపోయినప్పుడు ఇంటిగ్రిటీ అనేది ప్రివేల్ అవుతుంది గవర్నమెంట్ ఆఫీసులలో, హానెస్టీ అనేది ప్రమోట్ అవుతూ ఉంటుంది. thus they ensure the government government offices, right? Another key feature is fairness in law. Laws are applied uniformly and impartially, ensuring justice for all. సో లాస్ అనేవి ఏవైతే ఉన్నాయో ఒక ఈక్వల్ అప్లికబుల్ అయ్యే వారికి అందరికీ సమానంగా చేయబడతాయి వితౌట్ ఎనీ పార్షాలిటీ. దీనివల్ల జస్టిస్ అనేది ప్రమోట్ చేయబడుతూ ఉంటుంది. వాట్ ఈస్ ద ఇంపార్టెన్స్ ఆఫ్ దిస్ వన్? లీగల్ ప్రొసీడింగ్స్, ఆల్ ద లీగల్ ప్రొసీడింగ్స్ ఆర్ fair, are done in a fair manner, in an unbiased manner, right? In unbiased manner. This principles helps in upholding the credibility of the legal systems. Credibility, it promotes the credibility of the legal systems, and at the same time it ensures the old age adage that justice is not only done but also seem to be done. Justice is not only done but also seem to be done. ఎప్పుడైతే లాస్ అనేవి ఫెయిర్గా అందరికీ అప్లై అవుతాయో దెర్ విల్ బి అన్ యూనిఫార్మిటీ అండ్ ఇంపార్షియాలిటీ ఇన్ ద జస్టిస్ సిస్టమ్. సో హెన్స్ ఇట్ ప్రమోట్స్ క్రెడిబిలిటీ ఇన్ ద జ్యుడిషియరీ. క్రెడిబిలిటీ ఉండడం ద్వారా జస్టిస్ అనేది ప్రివేల్ అవుతుంది. జస్టిస్ అనేది నాట్ ఓన్లీ ఇన్ అ ప్రొసీజరల్ మేనర్ బట్ ఆల్సో ఇన్ అ సబ్స్టాన్సిటివ్ మేనర్, రైట్? సో అందువల్ల ఫెయిర్నెస్ ఇన్ లా అనేది ఉపయోగపడుతూ ఉంటుంది. Like another thing is protection of rights. Fundamental rights and liberties are protected by the laws. In a rule of law concept, these fundamental rights and liberties are protected by the law itself, preventing the arbitrary actions by the state. ఆర్బిటరీ యాక్షన్స్ అనేవి ఏవి ఉండవు. సేఫ్ గార్డింగ్ ద ఇండివిజువల్ ఫ్రీడమ్స్ అండ్ హ్యూమన్ రైట్స్ ఈజ్ వెరీ వెరీ ఇంపార్టెంట్, రైట్? బికాస్ it is a foundation, very foundation of a democratic society, very foundation of a democratic society. Only then people can exercise their rights, people can exercise their right without any fear, without any fear and oppression, even to that matter discrimination, without any fear, oppression and discrimination, రైట్? ఫండమెంటల్ రైట్స్ అనేవి రూల్ ఆఫ్ లాలో ప్రొటెక్ట్ చేయబడుతూ ఉంటాయి. ఎందుకు? ఆర్బిటరీ యాక్షన్స్ ప్రివెంట్ చేయడానికి. ఆర్బిటరీ యాక్షన్ ప్రివెంట్ చేసినప్పుడే పీపుల్ కెన్ ఎంజాయ్ దర్ రైట్స్ ఇన్ అ ఫ్రీ మేనర్ వితౌట్ ఎనీ ఫియర్, రైట్? సో వితౌట్ ఎనీ డిస్క్రిమినేషన్, వితౌట్ ఎనీ అప్రెషన్, రైట్? సో ఇది అనదర్ salient feature. Another thing is independent judiciary. Courts and judges are independent. They are free from political or external influences, thus ensuring the unbiased adjudication. Unbiased adjudication. Importance ఎందుకు? ఇండిపెండెంట్ జ్యుడిషియరీ అనేది చాలా చాలా ఇంపార్టెంట్ ఫర్ ఫెయిర్ ఇంటర్ప్రిటేషన్ అండ్ అప్లికేషన్ ఆఫ్ ద లాస్. ఇంటర్ప్రిటేషన్ అండ్ అప్లికేషన్ ఆఫ్ ద laws, right? So it acts as a check on the other branches of the government as well, on legislature and executive as well. ఇలా చేయాలంటే ఖచ్చితంగా జ్యుడిషియరీ అనేది ఇండిపెండెంట్గా ఉండాల్సిందే. జ్యుడిషియరీ అనేది ఇండిపెండెంట్గా ఉండాల్సిందే. దెన్ ఓన్లీ జ్యుడిషియరీ కెన్ ensure that legislature and executive act within their purviews, within their purviews, and do not overreach their domains, do not overreach their domains, and act within the constitution, act within the provisions of the constitution, right? సో అబ్యూజ్ ఆఫ్ పవర్ ఏదైతే ఉందో దాన్ని ప్రివెంట్ చేయడానికి యూజ్ అవుతూ ఉంటుంది. సి దిస్ కంప్లీట్స్ అవర్ ఫస్ట్ పార్ట్. సెకండ్ పార్ట్లో ఏమడిగారు క్వశ్చన్లో? సెకండ్ పార్ట్లో explain how this idea is reflected in the Indian constitution, right? So rule of law in the Indian constitution. The Indian constitution reflects the principle of rule of law through various provisions, establishing a legal framework that ensures justice, equality and accountability. Justice, equality and accountability. First thing first, preamble. Preamble talks about justice, liberty, equality and fraternity. Justice. Preamble aims to ensure the justice, social, economic and political for all citizens. This includes ensuring that laws are justly administered and everyone is treated fairly. Everyone is treated fairly. Another thing is liberty. It guarantees the liberty of thought, expression, belief, faith and worship. This protects individual freedoms and ensures that state does not arbitrarily interfere in these personal liberties, or while exercising their fundamental rights, state will not interfere in an undue manner. Another thing is equality. The preamble emphasizes equality of the status and opportunities as well, right? This underlines the importance of treating everyone equally under the law, everyone equally under the law, even providing the opportunities equally for all, even providing the equal opportunities for all. Another thing is fraternity. Fraternity is like it promotes a sense of brotherhood all citizens among all citizens. At the same time, it tries to ensure the dignity of individual and protects the integrity and unity of the country, right? Preambles. Thus, it provides a foundation for the rule of law. It provides foundation for the rule of law. Another thing is fundamental rights. Fundamental rights, Article 14. Article 14 ensures equality before law and equal protection of law. What does that mean? It means no individual or group of people are above the law. No individual or group of people are above the law, and all are entitled to equal legal protection. All are entitled to equal legal protection without any discrimination. It promotes the rule of law. Thus, it promotes the rule of law. Rule of law అంటే essentially ఏమి ఉండాలి? There should not be any arbitrary exercises of power. Everything should be done in accordance with the law, and everyone is subjected to the law, and law applicable to everyone, and law holds everyone accountable. See, this is a simple terminology, simple meaning of rule of law. ఇలా చేయడం వల్ల ఈక్వాలిటీ బిఫోర్ లా ఈక్వల్ ప్రొటెక్షన్ లా ఉండడం ద్వారా ఏం జరుగుతోంది? Every citizen or a group is given equal status before the law, right? So without any discrimination. Again, article 15 and 16, article 15 and 16, what does article 15 say? Article 15 prohibits discrimination on the grounds of religion, race, caste, sex, or place of birth, right? This ensures no citizen faces unjust treatment on these factors. How about article 16? Article 16 guarantees equality of opportunity in matters of public employment, ensuring that all citizens have equal chances to compete and succeed in the government examination for government jobs, right? So it provides. Thus, they ensure the rule of law. Another thing is Article 21. Article 21 protects life and personal liberty, stating that no person shall be deprived of these except according to the procedure established by law. Except according to the procedure established by law. This ensures that any deprivation of life or personal liberty must follow a fair, just, and reasonable legal procedure. Legal procedure, right? So no person, it protects life and personal liberty. No person shall be deprived of these things except లాలో మెన్షన్ చేసిన దాని ప్రకారం కాకుండా మరే విధంగా వీటిని తీసేయడానికి లేదు. వీటి ద్వారా ఏం జరుగుతుంది? ఒక ఫెయిర్నెస్ అనేది ఎస్టాబ్లిష్ అవుతుంది, ఒక జస్టిస్ సిస్టమ్, ఒక రీజనబుల్ లీగల్ ప్రొసీజర్ అనేది ఉంటుంది. Thus, this protects the rule of law. Another thing is Article 32. Article 32 provides the right to constitutional remedies, allowing individuals to approach the Supreme Court for enforcement of these fundamental rights. Right? So it is providing right to constitutional remedies. ఎవరైతే ఇండివిజువల్స్ వాళ్ళ యొక్క రైట్స్ ని డిప్రైవ్ అవుతారో దే కెన్ గో టు ద సుప్రీం కోర్ట్ ఆర్ ఈవెన్ ఫర్ దట్ మ్యాటర్ ఈవెన్ హై కోర్ట్ యాజ్ వెల్, రైట్? ఫర్ enforcement of the same. What does it do? This empowers citizens to seek judicial intervention if their rights are violated or compromised by state or other non-state actors, right? So again, even Article 32, these principles uphold the rule of law. Other thing, DPSPs, Article 38 and Article 39. Article 38 directs the state to promote the welfare of people by securing a social order permitted by justice, right? Informed by justice. So this include ensuring social, economic, and political justice for all the citizens of the country. At the same time, Article 39A mandates the provision of free legal aid to ensure that justice is accessible to everyone. కొంతమందికి ఏంటి, వాళ్ళ దగ్గర డబ్బు లేకపోవడం వల్ల వాళ్ళు ఒక లాయర్ని హైర్ చేసుకోలేరు. వాళ్ళకి జరిగిన అన్యాయం పట్ల ఒక గ్రీవెన్స్ రిట్రెసల్ మెకానిజంని పొందలేరు, రైట్? వాళ్ళ జరిగిన అన్యాయాన్ని తీర్చుకోలేరు. సో అందుకు ఏంటి అని అంటే గవర్నమెంట్ అనేది ఫ్రీ లీగల్ ఎయిడ్ అనే ప్రొవిజన్ని ఏర్పాటు చేసింది 39A, రైట్? కాన్స్టిట్యూషన్ ప్రొవైడ్స్ ఫర్ ఫ్రీ లీగల్ ఎయిడ్ టు ఎన్ష్యూర్ దట్ జస్టిస్ ఈస్ యాక్సెసిబుల్, రైట్? కొంతమంది దగ్గర డబ్బులు లేకపోవడం వల్ల ఎవరికి డినై అవ్వకూడదు, జస్టిస్ అనేది డినై అవ్వకూడదు ఎవరికి, వాళ్ళ యొక్క ఫైనాన్షియల్ స్టేటస్ వల్ల అంటూ ఈ ప్రొవిజన్ని తీసుకురావడం జరిగింది. దిస్ ప్రమోట్స్ ఈక్వాలిటీ బిఫోర్ ద law and ensures everyone has a provision or a everyone has a provision for legal remedies. Legal remedies. This is very important. Everyone has a access or a provision of legal remedy. At the same time, another thing is separation of powers. As part of the separation of power, there is an independent judiciary. Article 124 to Article 147, they provide, they discuss about Supreme Court. At the same time, Article 214 to 237 establish an independent judiciary to ensure impartial interpretation and application of law. Right? So, judiciary అనేది ఇండిపెండెంట్ గా ఉండాల్సిన అవసరం అనేది ఉంటుంది. అప్పుడే if other branches of the government, that is legislative or executive, if they overstep their domain or if they act anything not in accordance with the law or constitution, they can declare such actions as void, right? And thus they restore the justice. Thus they restore the justice. In order to ensure this thing, independent judiciary is must. So accordingly, Indian constitution provides for these provisions. These provisions in the articles 124 to 147 for Supreme Court, 214 to 237 for High Court, right? So this allows impartial interpretation of the law and fair application of the law. Another thing is checks and balances. The Constitution provides for a system of checks and balances among the legislative and executive judiciary branches. What is it? What is the importance of this one? This prevents any branch from becoming too powerful and ensures that each branch can act as a check on the others. Check on the others. Thus maintain the balance of power. Thus they maintain the balance of power. Right. Another thing is judicial review under Article 13. What does it say? Article 13. Article 13 empowers the judiciary to review the laws and executive actions and declaring them if they violate the constitution, if they are violative of the constitution. This ensures that laws and actions are in conformity with the constitution, in conformity with the constitution, or in accordance with the constitutional principles, in accordance with the constitutional principles, right? At the same time, they are not exercising their power in a arbitrary manner. Another important thing is public interest litigation. Another important thing is public interest litigation, right? This enables judiciary to address issues affecting the public interest, ensuring the protection of fundamental rights and adherence to the rule of law. This ensures that judiciary take up can step forward and take up a issue that is affecting the fundamental rights of the people, that is affecting the fundamental rights of the people, even when the affected individuals cannot personally approach the court, right? So in under article 32, people can approach Supreme Court if their rights are being violated, but the concept of pill provides for the people to approach the Supreme Court even if they are not, or even if they are, do not have any locus standing in that particular issue, but if some action of the government or if some action of the executive is impacting the fundamental rights of the people, they can approach and seek the remedy as a whole, not just for the limited people. In this way, it ensures the rule of law in the country. Another thing is basic structure doctrine. Basic structure doctrine was promulgated in Keshavananda Bharati case in 1973. Supreme Court ruled that the rule of law is a part of basic structure of the constitution which cannot be altered by any amendment. Right? This doctrine ensures that certain fundamental principles, including the rule of law, remains inviolable and protect the constitution from arbitrary changes by the parliament or the legislature, right? So rule of law అనేది బేసిక్ స్ట్రక్చర్ గా చెప్పడం ద్వారా పార్లమెంట్ అనేది దీన్ని అమెండ్ చేయలేదు, ఈ పార్ట్ని అమెండ్ చేయలేదు అని చెప్పడం జరిగింది. రైట్. సో కంక్లూజన్, వాట్ ఇస్ ద కంక్లూజన్ దట్ వీ కెన్ సే? Conclusion is, rule of law is the cornerstone of the constitution that ensures the government is conducted in a legal framework, right? And at the same time, it promotes the justice, equality, and accountability, right? So the rule of law is vital element of the Indian constitution, and that governance is conducted within the legal framework that promotes justice, equality, and accountability. At the same time, actions like repealing the outdated laws and preventing the misuse of law and curbing the criminalization of politics is a step or essential step towards maintaining the rule of law in the country. We are just mentioning the things that are needed to be done to further promote the concept of rule of law in the country. ఏమేం చేయాలి అని చెప్తున్నాము? రిపీల్ ద అవుట్డేటెడ్ లాస్. ఎందుకు అవుట్డేటెడ్ లాస్ ఏవైతే ఉన్నాయో, స్పెషల్లీ బ్రిటిష్ ఎరాలో తీసుకొచ్చిన లాస్ అనేవి ఆర్బిటరీగా అప్లై చేయడం జరిగింది. ఎట్ ది సేమ్ టైం ప్రివెంటింగ్ ద మిస్యూజ్ ఆఫ్ లాస్, రైట్, క్లియర్ డెఫినేషన్, లాస్లో ఉన్న వేగ్నెస్ని తీసివేయడం ద్వారా వీఆర్ ప్రివెంటింగ్ ద మిస్యూజ్ ఆఫ్ లాస్. At the same time, curbing the criminalization of politics, because those who are influencing the power, they may exercise, they may show disregard for the rule of law. These are the essential steps towards maintaining and upholding the concept of rule of law in India. Let us look at another question. Checks and balances as well as separation of powers are not mere intellectual ideas but principles which strengthen a democracy in real ways. Discuss in the context of India. Discuss in the context of India. The topic ఏంటి? Topic is separation of powers. At the same time, checks and balances. But the core topic is separation of powers. Checks and balances is, again, it comes in the context of separation of powers itself. Separation of powers itself. ఇక్కడ ఏమడుగుతున్నారు? These are not mere intellectual ideas, but would ultimately strengthen the democracy, it seems. We have to prove that aspects. So checks and balances and separation of powers అనేవి ఇంటెలెక్చువల్ ఐడియాస్ మాత్రమే కాదు, బట్ అవి డెమోక్రసీని బలోపతం చేస్తాయి, డెమోక్రసీని స్ట్రెంగ్తెన్ చేస్తాయి అనేది మెన్షన్ చేయాలి. హౌ డు దే డూ దట్? వీ హ్యావ్ టు ప్రూవ్ ఇట్. అండ్ దే ఆర్ ఆస్కింగ్ us టు డిస్కస్ ఇన్ ద కాంటెక్స్ట్ ఆఫ్ ఇండియా, ఇండియన్ కాంటెక్స్ట్ లో. దట్ మీన్స్ ఇండియన్ ప్రొవిజన్స్ కాన్స్టిట్యూషన్లో ఏవైతే ఉన్నాయో వాటిని హైలైట్ చేస్తూ ఆన్సర్ని రాయాలి. రైట్. సో ఫస్ట్ థింగ్, టాపిక్ ఈస్ separation of power. What is the meaning of separation of powers? It is a political doctrine. It is a political doctrine. It is a political doctrine in which the powers and responsibilities of government are divided into various branches, right? Like legislative, executive, and judiciary. To limit any one branch exercising only its core functions, right? So to limit any one branch from exercising the core functions of another one. So their concentration is only to exercise the one's own assigned powers, right? So మెయిన్ ఉద్దేశం ఏంటి దీంట్లో? వాటి ఏదైతే లెజిస్లేటివ్ ఉందో లెజిస్లేటివ్కి ఇవ్వబడిన పవర్స్ మాత్రమే ఎక్సర్సైజ్ చేయాలి, వాటికి ఇచ్చిన డ్యూటీస్ మాత్రమే ఎక్సర్సైజ్ చేయాలి, వాటికి ఇచ్చిన రెస్పాన్సిబిలిటీ మాత్రమే ఫుల్ఫిల్ చేయాలి. ఇట్ షుడ్ నాట్ ఎంటర్ ఇన్ టు ద డొమైన్స్ ఆఫ్ ఎగ్జిక్యూటివ్ అండ్ లెజిస్లేటివ్. దిస్ ఇస్ అ separation of powers in a stricter sense, not in Indian context. In a stricter sense, separation of powers refers to the division of government's responsibility into various branches so as to limit any one branch exercising the powers of another branch. In the India, division of powers is instated in the constitution. Constitution లో క్లియర్గా డివిజన్ ఆఫ్ పవర్ అనేది మెన్షన్ చేయబడి ఉంది, which delineates the roles and responsibilities of legislative, executive, and judiciary in a comprehensive manner. This separation of power is a fundamental aspect of the constitution and it's a basic structure అనేది లో ఇంటిగ్రల్ పార్ట్. సెపరేషన్ ఆఫ్ పవర్ అనేది బేసిక్ స్ట్రక్చర్లో పార్ట్. Another thing is, Indian constitution provides for a system of checks and balances as well, where each branch has authority to monitor and limit the actions of another. Checks and balances and ఏంటి, where individual branch has the power or authority to monitor and check the actions of another branch, thus ensuring that no single institution can dominate or undermine the democratic framework. Right. So ensuring that no single institution becomes too powerful and undermines the democratic framework itself. Right. So Indian Constitution లో both the features. That's a separation of powers అనేది మెన్షన్ చేయబడింది. At the same time, it also contains provisions related to the checks and balances as well. Let us see how they are enshrined in the Indian Constitution. Right. So first thing, separation of powers that strengthen the democracy. How does it strengthen the democracy? First thing, it prevents the concentration of power. Separation of powers divides the responsibilities of the government into three organizations, right? Three organs. That is legislative, executive, and judiciary. That means no single branch can accumulate the excessive power. Legislative is responsible for enactment of the laws, for making of the laws. Right? Legislature means parliaments or state legislative assemblies. They are responsible for making the laws. Executive is responsible for implementing and enforcing these laws. Right? The executive includes in a central level the president, prime minister, and council of ministers and various administrative agencies, whereas judiciary is responsible for interpreting the laws and adjudicating the adjudication of legal legal disputes. These includes courts, Supreme Court, High Courts, and various district courts as well. Thus, there is a clear division that ensures no single branch holds all the powers, right? That could lead to misuse and abuse of authority. See, ఒకటే బ్రాంచ్ అనేది too powerful అయితే there are chances that it may misuse or abuse the power that is accumulated to it, right? So it reduces the risks as well. It reduces the risks of arbitrariness. When a power is concentrated in only in one branch, the decision can be made arbitrarily without proper checks and balances. Right? Authoritarianisms. A single branch holding excessive power can lead to an authoritarian rule where the government operates without any accountability to the people. And the separation of powers promotes a balanced governance, right? A balanced and accountable governance where each branch can check the powers and authority of others, preventing any form of dictatorship or totalitarian regime. Dictatorship or totalitarian rule or regime, right? So it prevents the concentration of power. Another thing is it enhances the specialization and efficiency, right? How does it do specialization? By having a distinct branches for each work, right? So by having distinct branches for each of its functionality, right? For legislature, enactment of laws, executive enforcement of the laws, for judiciary, interpretation and adjudicating the legal disputes. It is promoting the specialization. It is promoting the specialization where legislature can create legislature can focus on the laws and it can go through the legal aspects while framing the laws, right? So needs of the society can be best understood by the legislature. So it includes the drafting, debating and passing the legislation. At the same time, law enforcement, that means executive, it focuses on implementation aspect, right? So it can enforce these laws effectively and it can manage the public administration very well. At the same time, it can conduct various operations like foreign policy or defense policy, atomic policies to a specific level, right? Through a specialization. At the same time, judiciary, it focuses on the interpretation of the laws like and resolving the disputes, thus ensuring that justice is served. This includes presiding over court cases, interpretation of the constitution and even protection of the individual rights. This specialization ensures that each branch operates with experts, right? So each branch operates with expertise, efficiency, and minimizing the errors. At the same time, it improves the quality of governance. It improves the quality of governance, overall quality of governance. At the same time, checks and balances. Checks and balances. Or we have to discuss the efficiency aspect as well. We have to discuss the efficiency aspect as well. Right? Efficiency meaning, see, it's like utilizing lesser resources to produce the intended outcome. Utilizing the lesser resources to produce the intended outcome. Suppose a person is working for 5 days and producing certain outcome or work delivering certain work by using 5 days. Another person, if the person is performing it in a 3 days and using lesser resources compared to the other person, this person is said to be more efficient, right? Utilizing the lesser resources to produce the same outcome is efficiency. Effectiveness meaning is ability to produce the intended outcome. Ability to produce the intended outcome irrespective of the resources. Utilization of the resources is called as said to be the effectiveness, right? So in creative field, effectiveness is more important even if some person is taking more days, more number of days and more number of resources to produce the output, it is accepted, right? But where the quality matters, where the output matters, right? So the difference between effectiveness and efficiency, right? So the focus on core responsibility can efficiency lead to more efficiency, right? Each branch concentrates on its own primary duties without the interference from other branches. For example, if legislators are not involved in the enforcement of the laws, if their primary task is to concentrate on the public policies and do the research, survey and analysis of the public needs, right, it improves the legislative aspect. Same as the executive, if it is concentrating on the enforcement aspect, it can identify the better means of enforcement of particular law, right? So the division focus on the core responsibilities increase the efficiency as well. At the same time, it streamlines the processes. Separation of powers allows the streamlination of processes where the responsibilities do not overlap unnecessarily. It reduces the conflicts. At the same time, it increases the operational efficiency. Thus ultimately it provides for improved governance by allowing each branch to develop specialized knowledge and skill set, right? The quality of governance will be improved substantially, right? So another aspect is checks and balances. Checks and balances is each organ is having a control on the other body in a some or other manner. That is the concept of checks and balances, right? So each body of the each organ of the government is having a control and authority over the other organ of the government, right? Thus it limits the excessive power that is being exercised, or even it corrects if other branch of the government is committing any error or any mistake, right? So we have to see how judiciary ensures on legislature. First thing is judiciary's primary responsibility is to interpret the laws in a fair manner and to ensure the laws are applicable in a fair manner. Interpret and ensure the applicability of the law is fair and just, right? So this is the primary responsibility of the judiciary. See, on legislature, how it is having a oversight. legislature can review and strike down the laws that are unconstitutional or arbitrary, right? We had seen in the case of NJAC act, where this particular act was declared as unconstitutional for it is having a say in the judiciary appointment, excessive say rather, excessive say in the judiciary appointment, thus violating the principle of separation of powers, thus undermining the basic structure of the constitution, thus undermining the basic structure of the constitution. Judiciary can declare a particular law as unconstitutional and arbitrary if it is ultra vires to the constitution, if it is violating the principle of basic structure, right? So on executive, even judicial review allows the executive to examine the judiciary executive actions for constitutional conformity and providing safeguard against the arbitrary and unlawful actions by the executive, right? Even judiciary can monitor the executive actions and declare them unconstitutional if they are exercised in an arbitrary manner or unconstitutional manner, or if they are overstepping the powers, right? Or if they are not having any jurisdiction in that particular concern, right? Example could be, famous example, recent example, Shreya Singhal case, where 66A Act of IT Act was struck down by the judiciary for it is violating the basic basic fundamental rights of individuals that are right to life and liberty free. Thus, it also negated the executive action of arresting these particular lady, Shreya Singhal, right? At the same time, there are many cases, Maneka Gandhi case as well, even the SR Bommai case, where president rule was imposed in an arbitrary manner, where president rule was imposed in a arbitrary manner, violating the basic structure of the constitution. Judiciary has struck down the executive actions, central government's actions in this case as well. You can mention these examples, right? So, on the legislative role over judiciary, legislature can impeach the judges for their incapacity and misbehavior, ensuring judicial accountability. రైట్, ఎప్పుడైనా జడ్జెస్ మిస్బిహేవ్ చేసినా లేదంటే వారి యొక్క ఇన్కెపాసిటీగా మారినా కూడా వారిని ఇంపీచ్ చేసే అధికారం అనేది లెజిస్లేచర్కి ఉంది. ఇట్ హ్యాస్ పవర్ టు అమెండ్ ద లాస్ ద జుడిషియరీ దట్ ద జుడిషియరీ హ్యాస్ డిక్లేర్డ్ అల్ట్రా వైర్స్ అండ్ రివాలిడేటింగ్ them in line with the constitutional provisions. ఎప్పుడైతే చూసాం కదా ఇక్కడ జుడిషియరీ రివ్యూ ద్వారా ఎప్పుడైతే ఏదైనా జుడిషియరీ రివ్యూ ద్వారా కోర్ట్స్ అనేవి పర్టికులర్ లాస్ ని అన్కాన్స్టిట్యూషనల్ గా డిక్లేర్ చేసినప్పుడు legislature has the power to make amendments to these things and make them in comply with the constitutional provisions as well, in compliance with the constitutional provisions, thus they are revalidating the along with the revalidating them along with the constitutional principles. Example, famous example, recent example, 2018 లో సుప్రీం కోర్ట్ అనేది ఒక వర్డిక్ట్ ఇచ్చింది అగేన్స్ట్ యాక్ట్ అగేన్స్ట్ ఎస్సీ ఎస్టీ యాక్ట్ ఇన్ సుభాష్ కాశీనాథ్ మహాజన్ వర్సెస్ స్టేట్ ఆఫ్ మహారాష్ట్ర కేస్. సుభాష్ కాశీనాథ్ Mahajan versus State of Maharashtra. Supreme Court has introduced certain safeguards to prevent the misuse of SC/ST Atrocities Act. What are these things? Preliminary inquiry. Preliminary inquiry should be done before the registration of FIR. And at the same time, sanction for the arrest. If they are arresting any public servant, they needed the approval from the authority who has appointed this particular public servant. At the same time, if someone is arresting the private person, the permission from senior superintendent of police was required. At the same time, anticipatory bail was allowed in these cases, right? But Supreme Court when Supreme Court has declared these provisions, Parliament has come up with the Amendment Act. Parliament has come up with the SC/STs and Prevention of Atrocities Amendment Act 2018. SC/STs Amendment Act 2018. It said that no preliminary inquiry was required. It has said that no preliminary inquiry was required for registration of the case or registration of FIR under the Act. At the same time, no sanction for arrest. It has removed the requirement for prior approval of authorities, right, for arrest. At the same time, no anticipatory bail in these cases, right. So it has explicitly stated that no anticipatory bail can be granted when a case is registered under the SC/ST Act. When a case is registered under the SC/ST Act, thus judiciary has the power to amend the laws that were declared ultra vires by the Supreme Court or any High Court for that matter, and can revalidate them in line with the constitutional provisions. Said at the same time, on executive, this is a core foundation of the democratic system of a parliamentary democracy for that matter, right? That legislature exercise control over the executive, means it holds the accountability of the executive through mechanisms like vote of no confidence, question hour, 0 hour, right? Additionally, it can impeach the head of the head of the government, that is nothing but the president, right? So it can impeach the president for constitutional violations as well. So hence, judicial legislature has certain power, right? So another thing is executive role. Another thing is executive role over judiciary. The appointment of judges. First thing is appointment of the judges. Right. Executive is integral part of this process. The executive, through president, appoint the judges to the Supreme Court and High Courts. The influence and the judiciary's composition ensures that the executive has a role in shaping the judiciary's landscape. That means it says that the consent provision states that the president, in consultation with the collegium, appoints the judges, right? In consultation with the collegium, appoints the judges. This consultation has certain evolution through the three judges case, but government's approval, that means executive's approval, is mandatory for appointment of any judge, right? So it has significant say, though it has limited, but has significant say in the judicial appointments, right? At the same time, over legislative, it has first thing, it has delegated legislative powers. That means uh, legislature only makes the laws. It is the executive which makes the bylaws, the rules and regulations, consent procedures, right? Legislature enacts only a law which outlines the basic objectives. It is the executive that determines the exact provisions, rules, laws, criterias, right? So by having a power of delegated legislation. At the same time, it has a power of issuing ordinances. It has power of issuing ordinances as well. President can issue ordinances when the parliament is not in session, right? Thus allowing the executive to address the urgent matters. Allowing the executive to address the urgent matters, sir. It has certain say on the legislature as well. Has a say in the legislature as well, రైట్. సో మనం క్లియర్గా మెన్షన్ చేసాము ఏంటి సెపరేషన్ ఆఫ్ పవర్ అనేది ఎలా డెమోక్రసీని స్ట్రెంథెన్ చేస్తుంది. చెక్స్ అండ్ బ్యాలెన్సెస్ అనేవి. చెక్స్ అండ్ బ్యాలెన్సెస్లో ఎప్పుడు అయితే ఒక ఆర్గాన్ మీద చెక్ అనేది పెడుతుందో ఇంకొక ఆర్గాన్ అనేది, దట్ ఇండైరెక్ట్లీ ప్రివెంట్స్ ద అబ్యూజ్ ఆఫ్ పవర్, రైట్. సో ఎప్పుడైతే అబ్యూజ్ ఆఫ్ పవర్ అనేది ప్రివెంట్ అవుతూ ఉంది. ఒక ఆర్గాన్ అనేది రోగ్గా వెళ్తున్నప్పుడు అనదర్ ఆర్గాన్ వచ్చేసి దాన్ని బ్యాలెన్స్ ఆఫ్ పవర్ని రిస్టోర్ చేస్తుంది. రైట్. సో ఈ బ్యాలెన్స్ ఆఫ్ పవర్ని రిస్టోర్ చేయడమే నథింగ్ బట్ స్ట్రెంథనింగ్ ఆఫ్ డెమోక్రసీ. రైట్. ఎప్పుడైతే ప్రెసిడెంట్స్ అనేవి సెట్ అవుతూ వెళ్తూ ఉంటాయో there will be no interference of one organ in the other organ. Right. Now NJSC has been struck down. Right. Now the legislature or executive has least say in the appointment of judiciary. It has only final concurrence. Right. This judgment has set certain precedent. Now no other legislature or executive attempts to do the same thing, right? Attempts to do the same thing. Thus, it is preventing the misstepping again. That is nothing but strengthening the democracy, right? You have to establish, you have to understand this concept clearly. What's the conclusion? How can we write the conclusion? We are again reiterating the same thing by ensuring power is not concentrated in any single branch and by providing mechanism for mutual oversight and accountability. These principles help maintain a balanced and effective governance system. Mutual oversight and accountability is nothing but checks and balances. Right? This is separation of powers. Through separation of powers and checks and balances, we are ensuring a balanced and effective governance system. Right. What is the importance of this? This not only protects the rights of individual and liberties, also promotes the transparency, accountability, and ensures the rule of law. Not only protects the rights and liberties, but also promotes the transparency and accountability and rule of law, which are essential for a robust functioning of a democracy. Robust functioning of a democracy. Right. Let us look at another question. The expressions equality before the law and equal protection of laws may seem to be identical, but in fact they mean different things. Elaborate. See, question ఏమడుతున్నారు? Equality before the law and equal protection of laws. Equality before the law and equal protection of the laws may seem to be identical. రెండు ఒకేలా ఉంటున్నాయి, but in fact they mean different things. ఎలాబరేట్ అనేది ఇక్కడ కీవర్డ్. ఎలాబరేట్ అనేది ఇక్కడ కీవర్డ్. వాట్ ఇస్ ద మీనింగ్ ఆఫ్ దిస్? సి, ఏదైతే మన క్వశ్చన్ ఇవ్వబడిందో, ఏదైతే స్టేట్మెంట్ ఇవ్వబడిందో ఆ స్టేట్మెంట్ని విత్ ప్రూఫ్స్ ఎక్స్ప్లెయిన్ చేయాలి. విత్ ప్రూఫ్స్ అండ్ స్టాట్స్ డేటాతో ఎక్స్ప్లెయిన్ చేయాలి. దీన్ని సబ్స్టాన్షియేషన్ అంటాం. రైట్. We have to substantiate the given statement. రైట్. సో ఇది ఇక్కడ ఏమడుతున్నారు, దేని గురించి? ఇది ఆర్టికల్ 14 ఆఫ్ ద ఇండియన్ కాన్స్టిట్యూషన్. రైట్. సో ఇక్కడ మనం మాట్లాడుతున్నది ఆర్టికల్ 14 ఆఫ్ ఇండియన్ కాన్స్టిట్యూషన్. ఇట్ సేస్ దట్ ఈక్వాలిటీ బిఫోర్ ద లా. ఆర్టికల్ 14 is all about equality, right to equality. Right. It's all about right to equality. Right. It has two components. One is equality before the law and equal protection of the laws. Equal protection of the laws. ఈ రెండింటి యొక్క డిఫరెన్సెస్ ఏంటి అనేది మనం ఎక్స్ప్లెయిన్ చేయాలి. ఫస్ట్ థింగ్, ఎప్పుడైనా కాన్స్టిట్యూషన్ ప్రొవిజన్ రిలేటెడ్ ఇచ్చినప్పుడు ఇంట్రడక్షన్లో నెంబర్, కాన్స్టిట్యూషన్ ఆర్టికల్ నెంబర్ రాసేసి వాట్ ఈస్ ద ఎయిమ్ ఏదైతే ఉందో ఆ ఎయిమ్ గురించి రాయండి. Like Article 14 of the Indian Constitution ensures that no person, whether a citizen or foreigner, is denied equality before the law or and equal protection of the laws. Equal protection of the laws within the country, within India. While both look alike, they are different, but at the same time they aim to promote fairness and justice. Right. They aim to promote fairness and justice. Right. So we need to discuss the concept of equality before the law. What is the meaning of equality before the law? This principle means that every individual in India is subjected to the same laws. Equality before the laws. That means everyone is subjected to the same laws. Right. So that all individuals within India are equal because they are subjected to the same laws. Right. So it emphasizes that no person or no group shall have special privileges, shall have special privileges because of their birth or religion, region, caste, or any other factors, right? So it emphasizes that no person or any specific group should have a special privileges because of their birth, religion, region, caste, race, sex, etc. Right? See, this is a negative concept. Primarily, this is a negative concept. What is the meaning of negative concept? Because it focuses on the absence of special privileges rather than giving a privilege. It acts as a no, a big no for special privileges, right? It emphasizes for the absence of special privileges. That's the reason we are calling it as a negative concept. దీన్ని మనం ఎందుకు అని అంటున్నాము? Rather than aiming to promote some positives, it says that there won't be any special privileges for anyone. సో కన్నెటేషన్లోనే ఒక నెగిటివ్ ఆస్పెక్ట్ లాగా ఉంటుంది, రైట్? ఇట్స్ అ నెగిటివ్ thing. It is a negative thing because it aims to prevent the special privileges for any sections of the society, right? Another thing is the origin. What is the origin? It has origin in the British common law. It has its origin in British common law. The concept of equality before law originates from the British common law. It is a fundamental aspect of the rule of law. It is a fundamental aspect of the rule of law. What is that rule of law promotes? Rule of law aims to promote the uniformity and fairness, fairness to the citizens, to the citizens, right? So it is a fundamental aspect of the rule of law which ensures that laws are applied uniformly and fairly to the all citizens of the country, all the citizens of the country. Application. What is the application of it? First thing, as we had seen, there are no special privileges to any individual or any section of the society, any sections of the society. Another thing is, laws must be administered by the ordinary courts, right? So ensuring that everyone receives the same treatment under the legal systems. It is simply meaning that everyone must be subjected to the same ordinary laws which are administered by the ordinary courts. That means everybody is subjected to the similar kind of laws, రైట్? సో అందరికీ ఒకే రకమైన లాస్ అనేవి వర్తిస్తూ ఉంటాయి. అనదర్ థింగ్ ఈస్ ద supremacy of law, right? So the law of the land is the highest authority, no one is above it, right? So any actions or policies act should be in conformity with the law of the land. సో ఏదైతే ఉందో లా అనేది అల్టిమేట్ గా ఉంటుంది. There is no one above the law, right? So these are the things, but there are certain exceptions as well. There are certain exception as well, because if the if the law prescribes if the law prescribes same kind of thing for highest ranking officers like president, governors, so that may not be practical, that may not be possible. So these offices are kept out of the purview of the equality before the law, right? Equality before the law. So they have certain privileges for president and governors. So these concepts do not apply to these two individuals, presidents and governors of various states. So, what is the best example of equality before law? Best example is for a penalty for a theft. A penalty for a theft. If the law prescribes penalty for a theft, every person who commits the theft, regardless of their background or social status, will be subjected to the same penalty, right? So, regardless of their background or social status, everyone is subjected to the same penalty. Another aspect is equal protection of laws. Equal protection of the laws. What is the meaning of this one? The principle means that the law should treat all individuals equally under equal circumstances. That means there is a law for empowering certain sections of the society. Assume that for SCs and STs, right? So when this law is made, this law should treat all SCs and STs equally. There should not be any discrimination again within this category, right? So it means essentially means that whoever under the similar circumstances, the law should them equally. Law should treat them equally. Law should treat all individual equally under equal circumstances. That is a essence of equal protection of the laws. Equal protection of the laws means that law should treat equals equally. So it is a positive concept requiring the state to take affirmative actions to provide facilities and opportunities to those who are in need, who are disadvantaged or who are unequal in certain aspects, right? So it is requiring state to take some affirmative actions, state to take some affirmative actions to provide facilities and opportunities for the people who have been disadvantaged, who have been facing the disadvantage or marginalized sections of the society. Origin, this is originated from the American Constitution. American Constitution. The concept of equal protection of law is derived from the US Constitution. It has been adapted and it has been adapted widely in many democratic countries and aptly for India as well. The application aspect is equal treatment. The state must ensure that all individuals receive the equal treatment in equal circumstances, equal treatment in equal circumstances in both the privileges as well as liabilities aspect, right? So the state should treat all the individual who are under equal circumstances, right? So the same law should apply who are similarly situated. That means uniform application. The same law should apply to all individuals who are similarly situated without any discrimination. At the same time, people in similar situation should be treated alike, ensuring that no one is subjected to the arbitrary discrimination based on irrelevant or unjustified factors, right? There should not be any arbitrary criteria for discrimination. If there is any intelligent criteria for discrimination, it is acceptable. If it is reasonable, it is acceptable. But there should not be any arbitrary criteria for treating people unequal గా ట్రీట్ చేయడానికి ఏ ఆర్బిటరీ క్రైటీరియాని యూజ్ చేయకూడదు, రైట్? సో బట్ it promotes for reasonable categorization. State can categorize people based on reasonable grounds such as socio-economic status, educational backwardness, right, or other relevant criterias, right? Why does it do so? It allows for substantive equality, right? Allows for substantive equality. This allows for the creation of laws, policies that aim to achieve the equality by addressing the specific needs of certain group of people, right? So the rational basis, the classification must have the rational a rational basis for such a discrimination. Discrimination it is a distinction. It is a distinction. It should be fair. The such distinction should be fair and just. Fair and just. So, an ultimate aim of such distinction is to achieve the equality, achieve the substantive equality. Examples, best example is for upliftment of the marginal sections of the society, such as reservations for SC and STs, and even physically abled people as well, right? So because of their certain circumstances that the socio-economic status of these people, government has come up with the affirmative actions to empower these people to stand equally to the to all sections of people. It has come up with certain policies for empowering these marginalized sections of people. So it has certain intelligence behind this categorization. Reasonable categorization is allowed. Hence, the state's actions are justified. justified. These measures primarily aim to bring the level playing field and to promote the substantive equality, right? So these are the differences and similarities between the equality before the law and equal protection of laws. Conclusion. What is the conclusion? See, both right to equality is a basic feature of Indian constitution as highlighted in the Indira Sahai case. The principle is crucial for democracy, right, allowing the judiciary to protect the rights for all individuals regardless of caste, class, region, race or place of birth. The distinction between these two things is a comprehensive one. Right? The distinction between these two is a comprehensive approach to achieve the true equality. That means substantive equality. The substantive equality. Fine. So the conclusion we are saying that both it is a basic feature, equality, right to equality is a basic feature, and both aim to protect the both aim to strengthen the democratic fabric of the country, and they promote the rights of individuals. They promote the rights of individuals. At the same time, the distinction is to allow the state to take certain affirmative actions and holistic approach to achieve the true equality, right? Equality, if state is promoting equal opportunities for everyone regardless of their present background, it is unfair to certain sections of society. Like some people may not have been educated, their parents might not have been educated. If state is not promoting through financial support, through scholarship, so that cannot stand as a substantive equality, right? It may be promoting equal opportunities, but it should also ensure that people have equal chances to fail or succeed, right? So that's the support, initial support for equal opportunities is called as this substantive equality, right? Let us look at another question. Discuss the significance and limitations of fundamental duties as enshrined in the constitution, right? So discuss the significance and limitations of fundamental duties as enshrined, that means as mentioned in the constitution. The topic ఫండమెంటల్ డ్యూటీస్. ఏది అడుగుతున్నారు వాళ్ళు? సిగ్నిఫికెన్స్ అడుగుతున్నారు. అట్ ద సేమ్ టైమ్ దే ఆర్ ఆస్కింగ్ ఫర్ లిమిటేషన్స్ ఆఫ్ ద ఫండమెంటల్ డ్యూటీస్. సో బోత్ ద థింగ్స్, సిగ్నిఫికెన్స్ అండ్ ద లిమిటేషన్స్, రైట్? సో ఇంట్రడక్షన్ రాయాలి. ఏం చెప్పాను? మెన్షన్ ద పార్ట్ ఇన్ విచ్ ఇట్ ఈస్ మెన్షన్డ్. ఆర్టికల్ పార్ట్ 4A, part 4A of the Indian constitution, right? Another thing is, what is the premise of it? What is the origin? Whether it was mentioned in the original constitution or not, right? So origin enti adi kuda mention cheyandi. That forms a good introduction, right? So introduction వచ్చేసి fundamental duties కి ఏంటి? The concept of fundamental duties was introduced in the Indian constitution during the internal emergencies period. Emergency, when the emergency was declared, it was introduced. The concept was introduced for the first time during 1975 and 77. It was incorporated into the Indian constitution through 42nd Constitutional Amendment Act. Right. It was placed under Part 4A to the constitutions following the recommendations of Sardar Swaran Singh Committee. Swaran Singh Committee recommendations మేరకు ఇది పార్ట్ 4A లో ఇన్కార్పొరేట్ చేయడం జరిగింది ఫండమెంటల్ డ్యూటీస్ని. సో త్రూ 42nd Constitutional Amendment Act, these provisions was placed under Part 4 of the Indian Constitution following the recommendations of Sardar Swaran Singh Committee. Sardar Swaran Singh Committee. These can be categorized as moral duties as well as civic responsibilities or civic duties. Moral duties meaning striving for excellence, right? Civic duties, example, protecting the environment, like protecting the environment. Moral duties aim to uplift the individuals. Civic duties aim to perform the individuals societal needs, right? So as a citizens, the person has to perform certain duties, right? These are referred as civic duties. This includes both of them, right? There is a significance of this one. What is the significance? First thing first, reminder of their responsibilities, right? Reminder of citizens responsibilities. Fundamental duties serve as the reminder to the citizens to perform specific responsibilities towards the society, to perform specific responsibilities towards the society. Example, citizens are reminded not to engage in activities like vandalizing the public property during any protest, such as these are against the society, right? It may harm the society, right? These are having the duty to protect the properties. Duty to protect the properties. You need to understand the situation as well, wherein it was brought under the emergency period లో certain moral conduct ని పీపుల్ కి ప్రమోట్ చేయడం కోసం, పీపుల్ కి ప్రిస్క్రైబ్ చేయడం కోసం ఫండమెంటల్ డ్యూటీస్ అనేవి ఎసెన్షియల్ గా తీసుకురావడం జరిగింది, రైట్? సో దీస్ డ్యూటీస్ యాక్ట్ యాజ్ ఎ డిటరెంట్ అగేన్స్ట్ ద యాంటీ సోషల్ యాక్టివిటీస్ ఆర్ యాంటీ సోషల్ బిహేవియర్స్. సో thus encouraging a law abiding and responsible citizenship, right? By reminding individuals of their societal obligations, the duty to help the maintain the public order and respect for the rule of law. These act as a reminders to the people. Another thing is promotion of patriotism and unity. Promotion of patriotism and unity. Right. Fundamental duties emphasize on the importance of respecting the constitution and the national flag, national anthem. Right. These are the symbols, national symbols. Symbols. Right? Example like standing up during the national anthem, saluting the national flag. These promote the national pride and unity. Right? Respecting such a national symbols fosters a sense of belongingness and fosters the pride among the citizens. Right? This unity is crucial for national integrity, especially in a diverse country like India, where the multiple countries, where multiple cultures, languages coexist with each other. These are very essential in promoting the national unity. Right? Another thing is encouraging the responsible citizenship. Encouraging the responsible citizenship. Right? So, by outlining duties such as upholding the national cause, such as the sovereignty and integrity of India, or defending the country and promoting the harmony in the society. Constitution encourages people to act responsibly and contribute to the nation building and nation well-being as well. Responsible meanings to take, to be mindful of one's own actions and decisions, and having a good overview of the consequences of their action. At the same time to promote the ownership of the actions as well, right? See, these duties aim to promote these responsible citizenship as well. Citizens are reminded constantly to protect the nation against any external threats, right? So encourages the citizens to prioritize the national interest, promoting the collective security and the cause of national unity. This responsible citizenship ensures that individual contributes to the country's development, country's growth, country's stability, and overall the country's unity as well. Another thing is social and ethical obligations. Duties like respecting the rights of others, protecting the public property, and striving towards the excellence foster a culture of responsibility, right? Culture of social responsibility and ethical behavior. See, such as examples like volunteering for community services or respecting the diverse cultures and religions in India. It promotes social harmony. It promotes social harmony, right? So, by fostering respect and responsibility, these duties aim to create a cohesive and morally upright society, right? Ethical behavior and social responsibilities are very very important for ensuring the well-being and progress of a community, without which communities collapses. There will be conflict in the communities, right? To promote harmony, we need good understanding between the communities. That comes only with a good understanding, that means empathy. So these duties aim to promote the empathy as well, right? Another thing is environmental awareness. We do know that present generation is facing one of the biggest challenge in terms of climate change. Climate change. So thus incorporating a fundamental duty to protect and improve the natural environment, including forests, lakes, rivers, wildlife. These duties promote the environmental consciousness, right? This highlights the importance of the environmental conservation and adopting the sustainable practices. So example like participating in a tree planting drives, avoiding pollutions and supporting the wildlife conservation cause efforts highlight the environmental responsibility. Right. Environmental conservation is so critical for sustainable development, especially in the present era. These duties encourage citizens to engage in eco-friendly practices, ensuring the preservation of natural resources for the future generations as well. That is the whole meaning of sustainable development concept, right? సో ఏవైతే మనం ఇప్పుడు రిసోర్సెస్ యూజ్ చేస్తున్నామో వాటిని జుడిషియస్గా యూజ్ చేయడం ద్వారా ఫ్యూచర్ జనరేషన్ కూడా వాటి యొక్క అవైలబిలిటీని ఎన్షూర్ చేయగలుగుతాము, right? So these are crucial aspects of environmental awareness. Our fundamental duties aim to promote the environmental awareness as well. Another important thing is cultural preservation. Cultural preservation, it encourages citizens to value and preserve and cherish the India's composite culture and India's rich heritage, right? That means these practices are continued in the future generation as well. Like example is like celebration of various festivals and participating in the cultural programs help help to preserve India's cultural heritage, right? Cultural heritage, for example, is even promoting classical music and dance forms is a way to keep these cultural traditions alive and taking these forward to the future generations. Cultural preservation maintains the diversity, right? Maintains the diversity and richness of the Indian heritage. It also promotes the sense of identity and pride among the citizens. When there is a sense of identity, pride, it invariably promotes the unity as well. Unity in diversity as well, right? Another thing is it has certain educational objective as well, such as promoting scientific temper and humanism, right? So promoting spirit of inquiry and reform is one such a fundamental duty, right? This aim to promote the scientific temper and humanism, taking a humanist approach for all the problems that the present world is facing, encouraging the scientific thinking, encouraging the scientific thinking and humanism in education, such as supporting science fairs, debates on human rights, even promoting the intellectual and moral growth, right? This makes India a these make India a global capital of intellectual intellectual capabilities. And we know that education is most important. It's a powerful tool for national development. By promoting and inculcating scientific temper, humanism, these duties contribute to the intellectual growth and moral development of the society. At the same time it prepares our citizens to face the challenges of the future and to find the solution for the present global situations, right? So intellectual growth is very important. It is promoted through the educational objective of the fundamental duties. It is also having importance in the judicial consideration. Supreme Court held that while determining the constitutionality of a law, if the court finds it the law seeks to give an effect to any fundamental duties, it may consider the reasonableness of the law. It may consider the law as a constitutional, though it is of violative of Article 14 and Article 19. Even if the principles of such a law are violating Article 14 and Article 19, it may consider law to be the valid. It may consider law to be the constitutionally appropriate if it is aims to promote fundamental fundamental duties. Example, laws such as promotion of or laws aim to promote the environmental conservation, put some regulations on the industrial pollutions and right environmental pollutions and human activities, the wildlife corridors or inside the forest areas. These are considered right because they aim to protect the environment, which is enshrined in the fundamental duties, thus it is having a value for judicial consideration as well. This judicial approach ensures that laws are aligned with the fundamental duties are protected protected and reinforcing the significance of these duties in promoting the societal welfare and justice in the society, right? The laws that are aiming to promote the fundamental duties, these will be considered valid even if they are of violative of article 14 and article 15. They not exactly violative if they are having certain relations to these 14 and 15 articles, they will be considered as a valid, right? They may consider the law reasonable in relation to the article 14 and article 19. They may consider the law reasonable in relation to article 14 and article 19, article 14 and article 19. So, but there are certain limitations as well for fundamental rights. What are these limitations? First, there are certain limitations of fundamental duties as well. First thing is ambiguity. See, there is a lack of precise definition. There is a lack of precise definition. Many fundamental duties are not clearly defined. Fundamental duties అనేవి clear గా define చేయబడలేదు, making it difficult for citizen to understand what exactly is expected from people, right? Making is చాలా డిఫికల్ట్ అయిపోతుంది పీపుల్ నుండి ఏమి వాల్యూస్ అనేవి ఎక్స్పెక్ట్ చేస్తున్నారు అనేది. ఎగ్జాంపుల్ ఈస్ డ్యూటీస్ సచ్ యాజ్ upholding the ideals of freedom struggle or developing scientific temper is very vague and broad in nature. See, మనం సివిల్ సర్వీసెస్ ప్రిపేర్ అవుతున్నాం, మనకి ఫ్రీడమ్ స్ట్రగుల్స్ యొక్క వాల్యూస్ ఏంటి, ఐడియల్స్ ఆఫ్ ఫ్రీడమ్ స్ట్రగుల్స్ అంటే ఏంటో తెలుసు. బట్ యాజ్ ఫర్ ఏ కామన్ సిటిజన్స్ ద ఐడియల్స్ ఆఫ్ ఫ్రీడమ్ స్ట్రగుల్స్ అని అంటే it's very difficult to comprehend, right? So it is very difficult for citizen to understand what exactly is expected from them, right? So this is ambiguity. The vagueness of these duties lead to the confusion. Vagueness of these duties lead to the confusion, right? At the same time, inconsistent application as well. So clear definitions are necessary to ensure that citizens can effectively understand and fulfill these responsibility. Another thing is non-justiciable nature. These are non-justiciable, right? They are moral postulate means suggestions, advices, right? These are only moral postulates. Fundamental duties are moral obligations, but they are not enforceable by a law. They are not enforceable by a law. What's the meaning? Meaning is simple. There is no legal obligation for citizens to comply. For citizens to comply with these things. If people are talking in a derogation of this freedom struggle, or if they are defaming certain personalities, right? Certain personalities who contributed to the freedom struggle, there is no action. There is no action taken under these things because they are not enforceable, right? There is no legal penalty for not adhering to the such things, right? So there is no legal penalty for not promoting the spirit of brotherhood, right? So the non-justiciable nature of these duties diminishes their practical impact, right? వాటి యొక్క ప్రాక్టికల్ ఇంపాక్ట్ ఏదైతే ఉందో అదే అనేది తెలుస్తుంది. ఇండియాలో స్పెషల్లీ ఎప్పుడైతే లీగల్ పెనాలిటీ ఉంటూనే దాన్ని అప్హోల్డ్ చేస్తారు, రైట్? సో because these are non-justiciable nature, people may not voluntarily obligate them, right? People may not voluntarily accept these and cherish these principles, right? Citizens are not legally bound to comply. So this is reducing overall effectiveness of these fundamental duties. Another thing is constitutional placement. Constitutional placement. These are placed in a separate part from the fundamental rights. Ideally, this should be placed immediately after the fundamental rights, enhancing or indicating the complementary nature with the fundamental rights. Right? Since they are separately mentioned, their value is diminished or profile is considered their profile is considered inferior to the fundamental rights. Obviously they are rigorously protected by the judiciary. These are not protected, not enforced. Hence the scope, the nature of these fundamental duties is very low. The separate placement may lead to the fundamental duties being overlooked, perceived as less important compared to the fundamental rights. Right. So they should have been ideally what should have been done? Integrating them more closely with the right could have enhanced their significance and awareness among the citizens. Right. Another thing is government duties. These are mostly centered around the citizens, right? Fundamental duties prescribe certain responsible for citizens, right? But they do not impose any duties on the government corresponding duties on the government. It says that people should promote rationality and scientific temper. What is a corresponding duty on the government? That is not clearly mentioned, right? This is not clearly mentioned. Citizens are expected of certain responsibilities, but the corresponding duty for the government to ensure the adequate protection and maintenance of these duties are not clearly defined or mentioned in the constitution. Thus it diminishes the importance of these things, right? So fundamental duties, in order to be effective, the government should also play a role in creating the conditions that enable citizens to fulfill these duties, right? So government should create the conditions, the enabling environment to fulfill these duties, right? This includes providing education, public order, economic opportunities. All they are correspondingly mentioned in the DPSPs and fundamental right, but they should have been mapped here as well. That's the point, right? Another thing is there is a repetition and overlapping. The clarity and distinctiveness is missing due to this one, right? The clarity and the distinctiveness is missing. Some fundamental duties overlap and they are repetitive in nature, which may lead to the redundancy and lack of clarity as well. Example duties emphasize the respect for constitution and the national symbols. So which could have been consolidated into a single duty, and their order as well. Order randomly placed. There could have been intelligent classifications like moral duties, civic duties, right? So the order is also missing. The classification also is missing. The redundant and overlapping nature of these duties confuse the citizens, right, about the responsibilities. Streamlining the duties to make them distinct and clear would improve their understandability and effectiveness of these fundamental duties. Another thing is there are certain duties that are missed in these fundamental duties section. Right. Certain important civic responsibilities are not included in the list of fundamental duties. Right. And the first important thing is voting. The duty to vote in election, which is crucial for democratic participation, that itself is missing. Another thing is paying taxes. The duty to pay tax, that is essential for the functioning of the state and contributing for the development of the country is another thing that is not included. Another important thing is family planning. Promoting family planning could contribute to the social and economic well-being, yet it is not listed in the fundamental duties. These things could have been included in the fundamental duties aspect, right? These things are not included. See, including the important civic responsibilities would engage more active participation, like, and it encourages the democratic process and societal well-being. Their absence only diminishes the comprehensiveness of these fundamental duties. Only diminishes the comprehensiveness of these fundamental duties. అర్థమవుతుంది కదా? ఓటింగ్ అనేది, పేయింగ్ ట్యాక్సెస్ అనేది, ఫ్యామిలీ ప్లానింగ్ అనేది ఐడియల్ గా ఉండాల్సింది. దే ఆర్ ద నెసెసిటీస్ ఆఫ్ ద టైమ్. దిస్ షుడ్ హావ్ బీన్ దేర్ ఇన్ ద ఫండమెంటల్ డ్యూటీస్ ఆస్పెక్ట్. Another thing is Conclusion. How do we draw a conclusion for this? The fundamental duties, despite their limitations, act as a code of conduct for the citizens of the country, promoting the responsibility, a sense of responsibility and patriotism, discipline. Right? These act as a code of conduct for the citizens, promoting the sense of responsibilities, patriotism, and discipline. However, there is a need to revise the current list to simplify the language, add more realistic and meaningful duties such as voting, paying taxes. Right? In this part, we are saying there is a need to revise this to make them more inclusive and effective. Inclusive and effective. Enhance the clarity and relevance of these duties will make them more effective in fostering responsible citizenship, and also remind the citizens of their duties while enjoying the fundamental rights. Thank you. Do practice these questions, and if you have any doubts, do mention in the comment section. Thank you.